Protector Busisiwe Mkhwebane has been interdicted from enforcing the remedial action against Pravin Gordhan in her South African Revenue Service or Sars report on the so-called rogue unit. The High Court in Pretoria made a finding that most of her remedial orders were vague, contradictory and or nonsensical. Mkhwebane, among others, directed President Cyril Ramaphosa to take appropriate disciplinary action against Gordhan within 30 days after investigation found that Gordhan violated the Constitution when he set up the so-called Sars rogue unit, which is alleged to have illegally spied on politicians. Minister Pravin Gordhan's lawyer, Tebogo Malatji, joins us now on the line. A very good evening to you, Mr. Malatji, and thank you so much for speaking to us. First of all, obviously, I'd imagine that the minister and his legal team are pleased with the ruling. Is that correct?
Evening to you and viewers. We are pleased with the judgment, and we think it's a reflection of what we've been saying all along.
Which is what? Can you summarize, obviously, what you've gone to court to achieve?
Well, let me put it this way. Our hand was forced to go to court in the sense that there were dates which were expiring in respect of what the public protector must do, what the president must do, what the Minister of State Security must do, and we had to approach court on an urgent basis. So we're pleased in the sense that all of that is suspended pending a proper ventilation of the issues, which we say we're right about and which the public protector we say we're wrong about. So that court process will unfold in due course.
I mean, we know that those who are opposed to the urgency or the application for urgency was saying that it was not urgent. What was the reasoning, the rationale behind that? Was that the subsequent legal case that was going to be brought up regarding the allegations against Minister Gordhan?
No, not at all. Not at all. The urgency was this. The public protector directed another organ, another sphere of government to act, and that was the Speaker of Parliament. She was required to do certain things within 14 days, and those 14 days expired on the 25th, which was a Thursday last week, and we had no option but to go on an urgent basis to ask the court to suspend those remedial actions. In the same vein, the president was required to do certain things by the 4th of August, which is 30 days from when she issued the report. And therefore, we had to go to court and say, suspend all of these things until a court has properly ventilated the matter.
I mean, I'm sure you would have noted some of the reactions, including from the EFF, that has criticized the ruling, saying that it basically makes obsolete the powers of a Chapter 9 institution to carry out its constitutional duties. Last week, Mkhwebane's counsel Thabani Masuku argued that the court itself, in granting the interdict, would be interfering with the legislative and constitutional terrain of institutions such as this. What is your reaction to this?
Well, let's all accept that ultimately the exercise of public power is subject to court review. If we accept that principle, that must include Chapter 9 institutions such as the public protector. So nobody, in other words, is above the principle that says law must rule. We call it the rule of law, and others call it the principle of legality. And therefore, when you subject a functionary's exercise of public power to judicial review, there must be deference to a court process which says, well, you might be right, you, in our case, the applicant, or you may be right, the public protector. So really, it defies any logic to suggest that nobody is subjected to the rule of law, including the public office of the public protector.
The matter of constitutionalism, or whether or not this was a constitutional matter was raised by the judge in the findings, but also given the fact that the Public Protector had said or raised the issue of the National Strategic Intelligence Act being violated. Where does the Constitution come into all of this, just from a layman's perspective? Because I'd imagine that just through all of this legalese, it would be difficult for some of us to understand.
From our perspective, it's as simple as this. Did the minister establish a unit which was intended to conduct intelligence service? Now, when you unpack it, layer by layer, intelligence service is intended to protect the security of the country. What did the minister authorize to establish? It's an investigative unit intended to combat illicit trade and people that avoid tax. And that argument has been carried by the court, which says, in the end, there's no evidence at all that minister established a unit to conduct intelligence service. Therefore, there's no contravention of the Constitution, and therefore there's no contravention of the National Intelligence Strategy Intelligence Act.
So I'd like you to react to this. The EFF already announcing that it had foreseen this outcome, that this is why they announced that they're going to take this matter to the Constitutional Court in appeal, also citing what they perceive as bias by the judge, saying that it appeared as if the judge favoured the white lawyers on behalf of Cyril Ramaphosa and Pravin Gordhan against those of the EFF and the Public Protector. Your reaction to this?
Well, if you read the judgment, it's very well written and balanced. Remember, we're dealing with very delicate and difficult matters. One of which was, as a judiciary, and she's a member of the judiciary, do you then intervene at this point, and how do you do so? So, firstly, do you let this poor man, who's the minister, suffer possibly irreparable harm, or is the judgment of the court going to interfere into what was argued to be an interference into another sphere of government? And what we say is balanced, rationally so, is, hang on, no, I just simply maintain the status quo. I say, let it be until a court on review determines the matter. So to our mind, there's really no argument to be made about anything, including, the unfortunate remarks made about, the color of the skin or anything of that sort. If you read that judgment, it's well written, and it says, in the end, I will maintain as a court today status quo, and another court on review, upon a full reflection of the matter, will then determine whether the Public Protector was correct in her findings or not.
All right, thank you very much for your time. Minister Pravin Gordhan's lawyer, Tebogo Malatji. And now, in your sports headline.